Let me show you something. Okay, this is from, you can get this on Pacer. This is Doc 142 10 CR 326, right? Just go on to Pacer, District of Minnesota, 10 CR 326. You're going to see the case come up. You do a docket report. You go to Doc 142. You could find this document, trial transcript. And this is where Patrick Doles, as I told you, who is my co-defendant, testified against me. And he was under the impression from the prosecution, and as I'll show you, he had been basically under their tutelage for some time, 3 or 4 years before he was ever represented by an attorney. But then his attorney continued to reinforce and tell Patrick for 2 years until he was sentenced, including over the time he testified against me, which I'm going to show you in these transcripts, continued to tell him, make him believe that he was going to get immunity. But they wouldn't put it in writing, apparently. So I guess, they told him they put it in their back pocket, and this allowed them to control Patrick, right? Let me show you. So we have to go to page 139 for Patrick Doles' direct examination. Patrick Doles, good afternoon. Good afternoon. So prosecutor says, I'd like to start by inviting you to tell the jury a little bit about yourself. So they've got this small talk, and they come down here to the meat and potatoes, I guess, as Mr. McLaughlin would call it. He said, I want to put some meat on those bones. So we're on document 142, page 140. Now, before we move into the subject matter at hand, I want to ask you some questions about a recent plea of guilty you entered before the judge presiding over this trial. So they're talking to Patrick Doles here. This is my trial, May 17th, 2011. Patrick Doles is on the stand. They're asking him about his plea deal before he testifies against me. You recently plead guilty to a conspiracy to commit mortgage fraud. Yes, I did. Do you remember when you entered that plea? I don't remember the exact date. I'm showing you the last page of your plea agreement. Mr. McLaughlin continues. Is that your signature on the last page of this agreement? It is. And it's dated what date, sir? 3/1/11. And so does that refresh your recollection that you appeared here in this court and pleaded guilty on March 1st of this year? Yes? All right, let's continue. What did you plead guilty to? Well, basically, conspiracy to commit mortgage fraud. And tell us, you can't put a plea in federal court without saying what you did. Is that correct? Correct. What did you do? What did you plead guilty to? And what did you tell Judge Doty you did wrong? Answer, well, basically, that I helped John Spencer facilitate in mortgage fraud. Question. I'm going to put the factual basis up on the screen. So this is the prosecutor now at my trial talking to Doles before he testifies, talking about that agreement and now the factual basis for that guilty plea. Correct me if I'm wrong, that you entered into a conspiracy with Mr. Spencer and others to commit mortgage fraud. Is that true, sir? Correct. And what was your role in that conspiracy? What was your primary role? To find lenders for his loan applications. And did you know those loan applications to be false and fraudulent when you were shopping them out to lenders? Yes. Let me call your attention to this document, 168-1, filed 11/8/2012. So if he testified on May 17th, 2011, and it's now November 8th, 2012, it's a year and a half after the testimony against me. And he filed these letters on his behalf, but the part we're looking for is his part, which begins on page 6. And this is what he says. And compare this with what he just said in court.
As for the loans that I did with Spencer, I must mention and speak about what I was thinking at the time. First off, I did not do my homework and find out if what he was doing was within the guidelines of the law. Previous to my work with Spencer, a loan officer named Kathy had the FBI come in and take her computer and loan documents. Chad Wakeschneider, the owner of Minnesota One Mortgage, called the FBI and turned her in. She apparently copied and pasted and changed the credit scores on many of her clients to show that they had better credit scores, thus qualified for the loan. Chad spoke with all of us and said if anybody does fraudulent loans, the same actions will occur. Kathy was a manager at the time of her arrest. Having said that, I had questioned John and Chad about certain items on the loans and got basically the same answer from both. These are good loans and you have nothing to worry about. Well, that is further from the truth as I now sit with my future in my hands. I'm not making an excuse for what happened, only shedding light on some things not stated. My intentions were never to commit fraud. I was only doing that the upper management asked me to do, take the loans and find lenders.
Now, there's a lot to unpack there, okay? But what he's doing is he's saying he asked management, including me, and he said, are these good loans? And he was told they were. His intention was also not to commit fraud. So here's somebody who doesn't think that they're committing fraud. And when they asked me, it's clear, all you got from me is that, no, these are good loans. So I clearly don't think that there's any fraud going on either. At least there's no evidence from that. So that is an entire change, 180 from what he just said at sentencing. You tell me. Go back to the trial, right?
What did you plead guilty to? What did you tell the judge you did?
Well, basically, I helped John Spencer facilitate in fraud.
What role was that you played?
To find lenders for his loan applications.
And did you know those loan applications to be false and fraudulent when you were shopping them out to the lenders?
Yes.
Okay, let's move on now. They also say that the government, it says, and what is your guidelines range that you and your lawyer and the government have stipulated to here? 30 to 37 months. So keep that in mind, right? What would be the foundation for that? Now let's continue to go down. He agreed to cooperate in this case. He goes,
yeah, I'm supposed to be a key witness in both of these trials.
What information are you supposed to provide?
The truth.
And are you going to do this? You've agreed to cooperate, I take it, because you want to break in your sentence. Is that correct? I take it that, like every other cooperating defendant, you're hoping that we will make a motion to Judge Doty and encourage him to give you something less than this guidelines range here.
Is that more or less your motivation for being here?
That is correct.
So is this, when we go to his sentencing now, when they say he doesn't have immunity or you weren't contemplating immunity here, let's just think about that, right? Because if you're involved with Spencer and you've got $7 million, the Hoffmans plus Spencer, and you're already contemplating that financial harm, how could you possibly say that you've stipulated to 30 to 37 months for your guidelines range, right? So let's keep going. Cooperate with the government against James Hoffman. This is where he thinks he's getting his immunity. If he testifies, he's going to get immunity in this one case. And here's what it says.
Now, before we get into this case,
My case.
I want to talk a little bit about the Hoffman case. In turn, for your plea of guilty in this case, the government has agreed not to charge you in another mortgage fraud case in which you participate. Is that true?
That's true.
But the loss amount for that case, was that included in this
Plea agreement. Answer.
Yes, it is.
Mr. Doles believed that the dollar amount was also included in not getting charged, right? It was all together, right? Let's see here. Here it is. And we're on page, guys, look this up. Doc 142, case 10CR00326 DSD. It was filed on February 7th, 2012. It's page 143. We're going to go down here to line 25. Question.
But the loss amount for that case, was that included in this plea agreement?
Answer.
Yes, it was.
So now, when we jump ahead a year and a half to when he's getting sentenced, Doles is under the impression that he has immunity for Hoffman. And we go back to trial. What he said is,
with this Hoffman case, my understanding is you're not going to charge me formally, and the loss amount is included in that plea deal.
So it's also not the same thing now as if he had like that in a written copy that he could feel secure in. But if he's being told that, something's still over his head or he's got immunity maybe, or it's just verbally being told to him, right? They can say, well, we're going to put that in our back pocket. And now you have to testify the way we want you to. So telling the truth here means telling what we say is the truth. And here's the kicker, guys. This is how I know for sure, right? Because I just called him up 2 days ago and I said, hey, Doles, man, think back to that time, right? And everything. Oh, he could think back to it. He knew right away. Did they tell you that you had immunity? He said,
yes, they did.
Did you think you had immunity?
Yes, I did.
So that's out of, that's right out of his mouth. That's what his impression was. That impression didn't come from just anywhere. As you're going to look in this next document, he cooperated right away without counsel. So he was under the tutelage of the prosecution for 4 years of the investigation, right? He didn't just come up with this idea about immunity. Someone told him that. And he would testify that that was told him. He would testify that that was told him in front of his attorney, is what he told me. So we're back in Doles sentencing, right? Doc 174, and we're on the bottom of page 6, right? And Doles' lawyer is saying,
and you must remember, certainly, his level of cooperation was great. And just to remind everyone, Mr. McLaughlin pointed it out too. It just wasn't he hired his lawyer, he started cooperating. The day they knocked on his door, the IRS agents, he started talking to them right then and there. Freely didn't hide anything. He was worried and he was scared. He knew something was wrong. But I think that's very telling in this case. And I don't usually see that.
okay, so now listen, I like to use government docs whenever I can. When I want to show you that they're aware of something, I've noticed them on something or some point that I raised, right? Because if they say, and we're going to go down to, this is their response, the delayed one in my 2255, the one that they needed to have a bunch of extra time on so that they could draft this based on the record. And so the reason why I like using government docs whenever I can is because if I say it, you can doubt me. But if they say it, it must be true. So let's go down to page 27, just so I can tell you what I said was going on. Spencer says that Doles' false testimony was likely achieved through behavior modification. That was in my 2255. Spencer's argument appears to be sweeping that none of Doles' testimony could have been true because Doles testified under the false pretense that he was a conspirator when in fact he did not have the mindset to be one. So that's what I was talking about at this time. At this time, I didn't have all the facts about this immunity promise that was made to Doles. I didn't have all the facts, right? And as I was putting that together, you remember, McLaughlin calls the prison that I'm at and has me shipped. And when I'm shipped, a foot worth of my legal evidence, pleadings, material disappears. Remember, Doles is sentenced on 11/29/2012. This is his attorney filing this argument on 11/8. So about 3 weeks before he's sentenced, he says,
I do not believe that it is fair or relevant to discuss in any form the Hoffman or Wegscheider cases, as Mr. Doles was never charged with these cases, was granted immunity on them, and has had no opportunity to defend himself on any allegations surrounding them.
11/8. Doles was sentenced 20 days, 21 days later on 11/29. So now we're back to sentencing, right? He's getting sentenced now, and his attorney just a few weeks ago wrote that paper saying,
my client's got immunity. We're not even going to talk about this. It would violate his rights.
And so now his attorney's like,
I just want to clarify, Mr. McLaughlin's correct. No one said immunity.
and they can't come out and say immunity now either, because then that would make what Doles said to the jury in my case a lie, and then couple that with this recantation. And David McLaughlin is aware that I've seen Doles' recantation, or at least he suspects that I have, because, after Mr. Ritz, his attorney, is kind of arguing for Doles to get some leniency here and explaining away Doles' immunity on Doles' behalf, right? What a great attorney that 3 weeks ago you were arguing for your client. So you must have been telling your client he had immunity. You must have been agreeing with him. You're a lawyer for years and years, but somehow this mistake got, this slipped past you. Now they're talking about the loss amounts and they're just saying, it was a difficult time. And they're talking about his level of cooperation.
He didn't go get a lawyer. He cooperated right away.
Which, again, that's why I say he was under the tutelage of the prosecution. If he had an idea of immunity, it was given to him by them, the prosecution, which he'll tell you that they told him that. They're talking about all the letters here. Now, here I want to share something with you. His attorney tells the court,
We did get an odd letter from Mr. Spencer. I think the court got that.
the court,
I got it. I think that's a good adjective.
Mr. Ritz,
Thank you. That's what Mr. McLaughlin said. I just showed it to him. He didn't get it, apparently.
the court,
I don't think I've been doing this now for 25 years. I don't think I've ever gotten, excuse me, dry air or something.
he must have got choked up there.
I don't think I've ever gotten a co-defendant who was testified against by someone to write a letter that Mr. Doles got from Mr. Spencer. It is highly unusual. I would say odd is a good objective. Mr. McLaughlin can comment on this too. He's been at this business a long time too, and I'd like to know if he's seen anything like that.
Mr. Ritz,
Well, I just want you to know I didn't write it.
the court,
You did not write it?
Mr. Ritz,
Well, I would have thought about it. I might have.
or Mr. Ritz says,
If I would have thought about it, I might have.
the court, well,
You could have written it as you
hey,
said.
Mr. Ritz,
It looks like I should have.
the court,
But Mr. Spencer is an unusual person too, and I suppose it didn't surprise me, but it was different, that's for sure.
right? It's a little bit of weirdness there. Now, let me give you a little idea about the letter. I said, listen, how are you guys going to lock Doles up? I said, Doles should go free. You bullied him into saying all this stuff. This is what I told the court. I said, you bullied him. He did everything that you asked him to do, right? You basically bullied this man. And let me tell you about Doles, right? Like when I got into business with Doles was the type of person who wasn't going to kill anybody, wasn't going to let anything die, right? This is a softie, right? And those are good business qualities, especially when you're dealing with customers, you're dealing with, high intense people who want things yesterday. To have a nice guy, somebody funny, witty, charismatic, good in a social setting like Patrick Doles, but a really nice guy, those were good qualities. And it was the government that made those into a negative, right? I didn't hire Doles to be a part of any criminal conspiracy. I didn't hire Doles to commit crimes with me. I didn't hire Doles because I thought he could stand up to the government, right? Because there was no criminal conspiracy. The government made all those soft qualities about Doles. The fact that he was a softie, they exploited that. They made that a bad thing. They took advantage of him. They abused and misused him. He went into court scared, thinking that he has immunity when he said the things that he said. So I wrote an argument on Doles' behalf that he shouldn't get any prison time at all. Let him go. Now, as we move down, the court says, okay, that's for sure. Then Mr. Ritz.
I think I've been very replete in my discussions with the court, my letters. I don't really need to hit it any further. And Mr. McLaughlin and I are in agreement, maybe 180 days seems reasonable.
Going down here, Doles ended up getting a year and a day. All right. So then Doles got a chance to talk, and Doles just basically apologized to his family, apologized to everybody. He didn't say anything really relevant to the recantation, but again, you can read it. It's Doc 174. It's in case 10CR 00326 DSD FLN, file 12/5/2012. And this is Doles' sentencing. And so now here Mr. McLaughlin gets up, and this is what he says.
Actually, I'm not going to say much. To answer the court's questions, I've never seen a letter like that one from Mr. Spencer. But then again, if I could figure out Mr. Spencer, I'd be a lot smarter guy than I am.
Right? So that's what the prosecutor's saying. And remember when I talked about how he stays up at night trying to think of ways to incriminate me because for years he was trying to get me to flip me, to turn me, to get me to build cases on other people. And I said no. And he just couldn't live with that. So he had to manufacture a case against me thinking he could force me to do it. Still couldn't do it. So now he's lying to people to get them to say things about me. And he's in here basically telling the court that, he'd be a lot smarter if he could figure me out. And the court's saying,
You'd have a different degree. You wouldn't have a JD. You'd have a doctor of psychology.
And then Mr. McLaughlin says,
Other than that, I really don't have anything to add to what Mr. Ritz said. What Mr. Doles said or to what we put in our recommendation of letter to our position. So thank you, Your Honor.
so McLaughlin, he doesn't even have to talk about immunity. Doles' lawyer, who's supposed to work for him and misled him, and 3 weeks before sentencing was arguing he had immunity, just lost immunity, just gave it away, didn't even make the other side contest it in open court.
Are you a criminal defense attorney? Well, let me introduce you to Strickland and Washington attorney insurance providers. Guaranteed foolproof coverage for all criminal malpractice claims. Let's go over some.
And now we want to go down here. Here's where I want to show you what the court said. So the court's going to talk about immunity now. It says
The defendant next objects to paragraph 33 through 35 of the pre-sentence investigation report, which attribute responsibility to defendant for mortgages involving James and Teresa Hoffman. Defendant argues that he was, quote, granted immunity, close quote, with respect to the Hoffman's mortgage fraud. However, while testifying at the trial of co-defendant Spencer, defendant stated that he understood the plea agreement included the loss amount from the Hoffman case, and therefore the government has met its burden, and the court will overrule the defendant's objection to the inclusion of the Hoffman mortgage fraud scheme.
So let's go back to what was actually said all the way back at my trial in 2012, page 143 of Doc 142, case 10CR00326 DSD. You can get this off Pacer. And the government asked Doles.
So you've agreed to cooperate in this case, correct? And in another case in which you participated, correct? And what is your understanding, your own words, of what that cooperation entails? What are you supposed to do?
Hey, I'm supposed to be a key witness in both of these trials.
Question, and what kind of information are you supposed to provide?
Answer.
The truth.
Question, and you are doing this, you've agreed to cooperate, I take it, because you want to break in your sentence, is that correct?
That is correct.
I take it that you, like every other cooperating defendant, are hoping that we'll make a motion to Judge Doty, encourage him to give you something less than this guidelines range here. Is that more or less your motivation for being here?
That is correct.
Now, before we get into this case, I want to talk a little bit about the Hoffman case. In turn for your plea of guilty, the government has agreed not to charge you in another mortgage fraud case in which you participated. Is that true?
That is correct.
But the loss amount for that case, was that included in this plea agreement?
Answer.
Yes, it is.
You see, they think everybody's stupid except them, right? They constantly try to pencil whip us, right? And they do it just in broad daylight, right? These semantic arguments that, if you look at them, don't say what they say that they say. Doles is saying that they've agreed not to charge me, and that's my sole motivation for testifying here today, is that. And the prosecution said, yeah, but
Is the loss amount included in that plea?
he says,
Yes, it is.
back to the sentencing. This is what the court said again. Defendant argues that he was, quote, granted immunity, close quote, with respect to Hoffman's mortgage fraud. And they say that while testifying against me,
That Doles stated that he understood the plea agreement included the loss amount from the Hoffman case, and therefore the government has met its burden and will overrule Doles' immunity argument.
I don't think the government met its burden. I think that Doles proved, and the court co-signed, that Doles believed that not getting charged for those crimes included any loss amount from those crimes. Otherwise, what's the point? And so let me go again to the recantation one more time, just read you one more time what Doles said before sentencing, right? So he said this before he knew the rug was going to get pulled out from under him even. He says, my intention was never to commit fraud. Let's look at what that says. Okay, and again, this is document 168, page 6, right? Case 10CR 00326 DSD-FLN. Get it on Pacer. We're going to go down toward the bottom of page 6.
As for the loans I did with Spencer, I must mention and speak about what I was thinking at the time. First off, I did not do my homework and find out if what he was doing was within the guidelines of the law.
So compare what he said at sentencing, which you just saw, with this.
I'm going to put the factual basis up on the screen. It says here, correct me if I'm wrong, that you entered into a conspiracy with Mr. Spencer and others to commit a mortgage fraud. Is that true?
Answer.
Correct.
And was your role in the conspiracy? What was your role in the conspiracy? What was your primary role?
Answer.
To find lenders for his loan applications.
Question.
And did you know those loan applications to be false and fraudulent when you were shopping them to lenders?
Yes.
Compare that to what he says at sentencing. Is that not a complete 180 recantation? And so it also says, right, because at trial he says he really didn't have no experience, he learned everything from me, but
Previous to my work with Spencer, a loan officer named Kathy had the FBI come in, take her computer loan documents. The owner of the company called the FBI and turned her in.
and so he's saying that, at this company, this happened. I had some experience with fraud and everything like that.
I was told by everybody that the loans are good, that fraud isn't tolerated here.
And he's also saying in here that I told him that. So if you look at it from the presumption of innocence, couldn't that mean that I also thought that the loans were good, that no fraud was going on here? That could have been the sole reason for me being there, was that I thought everything was fine. And he says,
My intentions were never to commit fraud.
now let's go back and compare to what he said in trial when he thought that he had immunity.
And did you know those loan applications to be false and fraudulent when you were shopping them out to lenders?
Yes.
I mean, that's completely different than what he's saying in his letter, is it not? This is my 2255 motion to vacate, set aside, or correct a sentence by a person in federal custody. We're going to skip down to page 82, and this is document 197-1, filed 12/17/13. So filed December 17th, 2013. This is page 1 of 73. This is the detailed 2255 the government said they needed all that time to respond to because they wanted to respond well-grounded in the record, is what they said. So we're going to go down to page 82. Was it 82 or was it 72? I think it was my page 82. Here it goes. Patrick Doles' written statement on record with the district court is essentially that at the time of the alleged knowing agreement to commit fraud, the conspiracy alleged by the government, Doles lacks the requisite intent to either commit fraud or knowingly join a conspiracy whose central objective was fraud. Quote, my
Intentions were never to commit fraud.
End quote. Doles asserts that he has not done his homework and didn't know whether or not the alleged unlawful conduct was, quote,
Within the guidelines of the law.
unquote. He further asserts that in the time leading up to the alleged unlawful conduct, he was fearful of committing fraud because what he had seen happened to another Minnesota One employee and had just been warned by his boss and owner of Minnesota One that fraud would not be tolerated. Moreover, prior to pleading guilty, he had
Talks with the prosecution.
and all of this ordeal put a
Considerable strain on his life, his wife, and children.
and also
Also, for 4 years,
Doles
had lived in fear.
Again, that's document 168-1 1. Let the record be noted that while under strain, worrying about his wife and family, and living in fear, Doles pled guilty to conduct he had no knowledge was not within the guidelines of the law. Never intending to commit the substantive offense, his concern for such matters was heightened by seeing a co-worker arrested by the FBI and warned by Chad. That's all in document 168-1, which Doles provided before he was sentenced after he testified against me when he's saying that the government promised him
Immunity.
Now, if you accept the fact that Doles was under the impression by both the U.S. prosecutor and his attorney that he
Had immunity.
when he made his recantation, when he testified against me before that, and at least 3 weeks before he was actually sentenced, and they pulled the rug out from under him with that semantic argument. When we look back at the trial when he testified against me, and we go to page 143 of document 142, and we go to the question here at number 14.
I take it that you, like every other cooperating defendant, are hoping that we will make a motion to Judge Doty and encourage him to give you something less than this guidelines range here.
Is that more or less your motivation for being here?
Answer.
That is correct.
Let the record reflect that his whole motivation for testifying against me is this agreement that he thinks he has, the one that he thinks he has. That's his whole motivation for testifying at this time. And this testimony is then recanted before sentencing. Okay, so we're almost done, right? I'm gonna flesh this out, right? Just bear with me. So this is, remember my 2255, the government's response. We're gonna go down to page 27 down here, but this was filed 5/30/2014. And this is the well-reasoned,
Well grounded in the record.
all the facts that belie what I'm saying. So we're going to go to page 27. The government says that Spencer notes
In a letter Doles sent to the court prior to Doles' sentencing, Doles wrote, "My
Intentions were never to commit fraud.
From this statement, Spencer argues,
and as you know, it wasn't just from that statement, but they say it is.
Spencer argues first that Doles perjured himself at trial. However, Spencer fails to identify what testimony by Doles was perjurous.
I think the conclusion of what testimony was perjurous is inescapable, but you do remember that they won't give me access to the transcripts of the record, and some of the transcripts, as I've shown, you can look at the last videos, weren't even released till a couple days ago, even though they were used and quoted against me extensively in this proceeding right here.
Spencer next argues that Doles' statement in his letter to the court undermines the factual basis of Doles' guilty plea.
I did say that. I said, if he went before you and said he never intended to commit fraud or join a conspiracy, he couldn't plead guilty. You couldn't accept a guilty plea to conspiracy. And so they say I should get
Credit for my creativity.
And they say, first of all,
This statement isn't new evidence.
that's what they say. In my 2255, and they argue
Spencer says that Doles' false testimony is likely achieved through behavior modification.
exactly right, because if it's in writing and it says immunity or he understands what's in writing, then everything's fine. But the moment you let him think he has immunity, you're going to pull some semantic agreement on him. You're going to say, well,
We'll just put that immunity in our back pocket now.
you're modifying his behavior because he knows he has to please you in order to get that thing you promised him that you're not willing to put on the table formally.
So the decision of whether to grant a new trial or not, based on new evidence, is governed by different standards, which depend on large part on the amount of prosecutorial misconduct.
See, there we are again with prosecutorial misconduct, right? And they said
The evidence must have been discovered after trial.
it was
The failure to discover the evidence must not be attributable to a lack of diligence.
on my part. Well, I don't see how it can, because here I am shortly after it happens, and then I get thrown in the hole, transfer, all that stuff happens. But as soon as I can, I'm raising it.
And the evidence must be material.
I think it's pretty material. And it says
The evidence must be likely to produce an acquittal if a new trial is granted, and
they're saying that I want to,
relaxed standard.
right? Because I argue that the prosecution knew or should have known that that was perjurous testimony by Doles. And so they even say that. They say,
For the court to apply the relaxed standard, the petitioner must establish that the testimony was in fact perjured, that the prosecuting officers knew or should have known of the perjury at the time the testimony was presented.
well, listen, you've been handling Doles, the prosecution has now, the time of my trial, for 4 years. He's recently now got an attorney. For this whole time, up until 3 weeks from sentencing, Doles thinks he has immunity. The court says that the government, at Doles' sentencing, the court says that the government proved their case by quoting Doles, saying that, yeah, I thought the finances are included in that deal, which makes no sense when you interpret it in the government's favor at all. You guys can rewind it back and tell me if I'm wrong, right? So it's this semantic cat and mouse. Doles is fooled. He's misled. The government should have known, right? They should have been very clear when they put somebody up to testify, right? They should be clear of that. And they certainly were aware that Doles thought that, because he thought that 3 weeks out from his sentencing when he argued that, and his attorney even argued it on his behalf. So here's what the court said. This is the order in my 2255.
Denied.
Evidentiary hearing,
Denied.
certificate of appealability,
Denied.
discovery.
Denied. No transcripts.
Let's go down to page 6 where he talks about Doles.
Specifically, Spencer argues following Spencer's trial and appeal, Doles recanted his testimony prior to sentencing. Spencer argues that as a result of the recantation, the sentencing court lacked a sufficient factual basis and should not have accepted Doles' guilty plea. Spencer further contends that because more than one individual is required to constitute a conspiracy, in the absence of Doles' guilty plea, the jury would have had reason to doubt the existence of the conspiracy and acquitted Spencer. Moreover, Spencer argues that the government knew or should have known of the perjury, but that it allowed Doles to proceed with his testimony. Doles argues that the prosecutorial misconduct claims based on Doles' testimony, though not raised on direct appeal, are not procedurally barred because he discovered that the government had allegedly suborned Doles' perjury only after his direct appeal had been resolved. Even if that were true, however,
Did you hear that? He said even if that were true. Is there any doubt at all that that's true?
However, Spencer cannot demonstrate actual prejudice. The jury's finding of guilt was not based on the guilty plea of Doles. Instead, the court specifically instructed the jury that Doles' guilty plea cannot be considered by you as any evidence of Spencer's guilt.
Oh, well, that cures it then, right? As long as the judge instructed him on that at some point during the trial, that cures it.
And further, to prove the existence of a conspiracy, the government must show an agreement between at least two people and that the agreement's objective was a violation of the law. Here, each charge of conspiracy related not only to Spencer and Doles, but also to Brian Lenton.
Therefore,
any alleged perjury testimony by Doles is not material because failure to disclose it would have been harmless beyond a reasonable doubt.
as a result,
Doles' testimony at Spencer's trial resulted in no actual prejudice.
So remember now, this is going to be you. This is going to be one of your family members. This is going to be their last chance, right? The last court action they have. And this is the quality of adjudication that they're going to get. So let's go back to when Doles testified. He testified on the first day of witness testimony. He was the second witness. The first witness was this Kelly Bodecker, a senior credit risk officer with Bank of America. And Bank of America, just to kind of throw this out there too, was a listed victim in my case. So Bank of America has a stake in me being the guilty party, not them being the guilty party. And the government calls up this person as another expert witness, Kelly Bodecker. And she's going to set the stage for the government. So she's going to be their teaching witness. They believe this is complex enough that the jury should hear from an expert what's really going on here. So they bring this person in to teach the jury. And
Bodecker was to be the first government witness called to explain mortgage underwriting standards and the considerations material to a lender in the underwriting context.
Right? And so keep that in mind. Okay, so let's go back to the day of Doles' testimony. Who's first? Kelly Bodecker. Who's second? Patrick Doles. Patrick Doles is the government's star witness. Their star witness just recanted that he was ever in a criminal conspiracy or ever had any intention to commit fraud. They had the teaching witness, and then they have Patrick Doles. Now remember what the court says. The court says that
even if all that were true,
I can't
show actual prejudice because
even though this is the government's star witness,
there's some other lesser witnesses in here that still might say that
I was
in the conspiracy.
But that's for the jury to decide. We don't know that they believed Brian Lenton. They might have believed Patrick Doles and then believed Brian Lenton because they believed Patrick Doles. And if that's the case, they might have disbelieved Brian Lenton if Patrick Doles
would have said something else.
So to say that there's no prejudice, but yet that's the star witness, that's the first witness after the teaching witness that you run out there. And why is that? Because you think Patrick Doles has the most damaging testimony against me. The testimony now that he's recanted. Okay, so now remember that Kelly Bodecker is in here to tell the jury that Spencer, defrauded the banks. And
This is how he did it.
Kelly Bodecker is a senior credit risk officer with Bank of America. So it sounds like she should be the one analyzing these deals. And, what if it's really Bank of America who enticed people that Spencer worked with or is covering up or concealing the fact that Spencer made all the disclosures he says that he made? So they have Kelly Bodecker from Bank of America. Okay, and that's important. Now let me just draw your attention to this document. This is document, I think it says 240, a little hard to read there, 241. And this is to Judge Doty. And this is talking about how, in this case, the servicer of the loan or lender was Bank of America. Bank of America has provided the government with a declaration of victim financial loss, indicating it is the servicer of loans for the property located at 332 5th Street. And they did that in the amount of $253,100. Now, this was on September 16th, 2016, and it makes comment to restitution $253,100, which was made payable to MERS, right? Bank of America had a $253,000 stake in me being guilty, and they supply an expert witness for the government. And that's the government's first witness. And then the second witness is Patrick Doles, their star witness, who recants his testimony about there ever being a criminal conspiracy. So, on day one of my trial, true or not, the government puts out their first witness, an expert witness from Bank of America, who later says they're a victim in the case, and they're awarded a $250,000, $250,000 judgment. This was never explained to the jury, however, and she's out there as the teaching witness telling the jury what's right and wrong, what the lender would rely on. And then right after her comes Patrick Doles, their star witness, and he's since recanted his testimony, but we've also learned that he was under the impression and his sole motivation for being there was the plea deal, which he thought gave him immunity from the Hoffman deals. And he thought that all the way up until just a few weeks before his attorney thought that all the way up just before a few weeks before he's sentenced. He makes that recantation and then he's sentenced. And then I'm shipped and all of my evidence disappears. Can I just ask you something? Could this be reason 101, reason 101 to do your jury duty, but to acquit in all federal cases? Could it be?